Everybody's ready? We'll now begin with the case of State versus Park. Mr. Sloven, you may begin.
Thank you, Madam Chief Justice, and may it please the court. Good morning. It's a privilege to be here. Ms. Park said what she chose to say and stopped when she chose to stop. Her free will was not overborne. Her statements were voluntary. Her Miranda waiver was voluntary. The Court of Appeals analysis, the first thing I want to say about it is that in concluding that her Miranda waiver wasn't voluntary, the Court of Appeals includes a number of facts that happened after the Miranda waiver, the implied Miranda waiver at the beginning, where she begins giving her description of events leading up to the 911 call. It is proper to analyze those facts in considering whether her later statements were voluntary. Her statements have to be voluntary the whole way through. We can't use evidence of involuntarily made statements. However, it's improper to, logically, things that happen later can't impact the voluntariness of statements that she makes earlier, can't impact the voluntariness of that initial Miranda waiver decision. So that's part one, is incorrect to consider her reaction to learning that Nam had died, incorrect to consider subsequent promises of leniency, which happened. I maintain there were no actual promises of leniency, but to the extent that you disagree, you could only consider those, and those would only require suppression of later statements under Madsen. When it comes to the deception, now I think that it is possible to envision a case where officers say, we are racing against time to save this person's life, and the only thing that can save them is your account of what happened. Tell us what happened. And where that, it's possible to conceive of a situation where that does have an impact on voluntariness. That's not this case. The reason we know that is from the facts as established by the video in the record. That, first of all, her decision to start talking, it doesn't come directly after they say, we need to know what happened because they're still trying to treat your husband. She still resists after that and says, I told you everything I know. Then they say, look, you can choose not to talk to us, that's fine, but we're still gonna sit here until we figure out what happened, which is true. They were getting a search warrant for her apartment, and so she could not leave even if she chose to exercise her Miranda rights. When the interview takes a break later, she stays at the police station while the search is ongoing. Then beyond that, the statements that she gives are, they tell her that they're patient, take your time. They cover a lot of detail, a lot of facts that can't possibly have any nexus to the treatment, if treatment were ongoing to try to save his life. Also, remember Cooper and Jacoby, one of the factors that they mentioned is that there's no substantial deceit about the gravity of the defendant's condition, that the defendant knows that the victim is, if not dead, at least gravely wounded. That's the case here. At the beginning of the interview, she says that she knows that he was cold to the touch. Also, we have facts, testimony in the motion to suppress hearing transcript establishing that she saw him as he was being, wheeled out of the apartment, saw the Lucas machine active and continuing that CPR. The officers never made any affirmatively deceptive statements like he's recovered and is fine. Now, I know this court doesn't condone deception and doesn't want to encourage officers to be deceptive, and that's a good stance. I think it's appropriate to say that when you find deception used by officers, it's that triggers a possible voluntariness effect inquiry, that upon officers using deception, then this court will consider whether that deception had an impact that overrode the suspect's free will and compelled the suspect to speak, forced them to make a decision to speak.
Are you distinguishing statements of deception from our promise of leniency type cases, the evidentiary rule, or are you treating those as the same thing?
They're very distinct, Your Honor. The evidentiary test only applies to promises of leniency because promises of leniency have, this court has said, have that effect where they can impact reliability potentially, and even though that's typically a weight of the evidence question, the evidentiary rule says we take that weight of the evidence question away from the fact finder and just don't allow statements after. Now,
Or point, can you address the statements regarding kind of the intimation that if she were a battered woman, then they would understand, maybe the implication that there's a battered woman's defense that would be available, which I believe is incorrect, and how that impacts the analysis?
there's a lot going on in those statements just because there's so many that are identified and all put together in the advocacy. So a lot of them are statements of empathy and understanding. A lot of them are timed after she's told of Nam's death. And they're, she's crying and they're talking to her and saying, it's okay. And then some others aren't. Some others are connected to her explanation. Empathy and understanding is not a promise, not an extrinsic benefit that counts as a possible quid pro quo for the purpose of a promise of leniency. Empathy and understanding, the reason for this is that, in Mullen, this court said—
Officer's statement that he would do something too, right? Didn't he say something along those lines? Which to me would imply, as a peace officer, doing something in response to that, like you did, is lawful. I mean, right? I mean, that's what you would have to infer. Not that the police officer said, I would do an unlawful act if I were in your situation, but if I were in your situation, I would do something lawful, and it's similar to what you did.
the very closest that any of these get to implying legal justification for any of it. The difference is that the officer is saying, I do something, but isn't saying I do a specific thing. It's not like Dennis or like McCoy, where the officer is describing a specific fact that if you admit to, it will establish a legal defense or lead to escaping punishment.
A lot of the statements strike me as sort of conditional, like if he was beating you and abusing you, that's not your fault. People would understand that. And I'm guessing when this case goes to trial, the state's going to attempt to prove that he was not the abuser, that she was. So what do you do with that, where it's a conditional statement that maybe the condition wasn't met? How do you manage that in terms of a promise of leniency?
I think that the conditional statement, you're correct to highlight that, because that is part of, and the conditional statements here generally are, if this is the truth, then that's understandable. Now, even that's understandable is like empathy and understanding, and that's something that officers can project and can build rapport. They can say, they can attempt to show the defendant that, or show the suspect that. In Mullen, the court says that confessions are admissible and proper when they flow from that goodness of the human spirit, that desire for the truth to be known. Empathy and understanding is a way for officers to communicate that, or to play off of that innate desire for the truth to be known, to be understood, and to say, is this what happened? And if they're right, and the suspect says in a moment, I'm glad somebody understands, that's what happened. That's good. Mullen is completely supportive of that. Polk additionally says that we like confessions that are voluntary and voluntarily made as a public good in helping to ascertain the truth. The conditional aspect, going back to answer your question more directly, the conditional aspect says, brings us back to the realm of don't tell us things that aren't true. It helps negate the reliability concern that we have with promises of leniency, that if the truth is this version of events, that's understandable, right? It's different from Dennis and McCoy. It's not, tell me this, and if you make this admission, here's the legal effect. Here's something you would receive in exchange for that. It's, if the truth about what happened is this, I get it.
It seems to me that the Court of Appeals read these statements to be, if this happened to you, we're going to protect you. We're going to sort of, defend you, or at least make it not as bad for you if this is what happened here. What about their reading of it was wrong? In sort of reading into it, kind of that that belief or that statement, that we're going to protect you?
Yeah, so there is one time in the excerpts where the officers say, we're trying to help you, protect you, if you will. But that, in the broader context, it's more clear that what they're talking about is the way that they're helping her is by having the truth be known. That's actually what he says, the officer says in the motion to suppress hearing transcript, is that rather than, and the officer makes it clear in the interview too, she says, do you think I killed my husband? And he says, I don't know. That's why we want the truth. That the way that the the most specific statement, non-specific statements are permissible. The most specific statement is that they're trying to help her by having a true version of facts be known rather than a denial that the evidence is tending to show is false, even at that point. And that's permissible. That's an intrinsic benefit of telling the truth, not an extrinsic benefit, something you receive in exchange for a particular admission where it would undermine the reliability of that admission.
Shift gears a little bit. I'm going to ask you about not the interview at the police station the night that Nam died, but the next morning when she comes back in. So she comes back the next morning. It's about 8 hours later. She's Mirandized right off the bat. She voluntarily shows up. She seems very composed. She starts out immediately and says, I'm gonna, I didn't tell you the whole story last night. I'm gonna tell you the whole story. Has kind of a very orderly story she sticks to, runs through that narrative. The Court of Appeals said that should be suppressed. I don't think we've really addressed what the standard is. If we assume there was an improper leniency in the promise of leniency in the prior statement, saying, when does that go away? When does that dissipate? When is it cured for purposes of this subsequent statement? What's the state's view of what that standard should be?
Part of this is made more difficult by the evidentiary test. There's not a lot of persuasive authority because the evidentiary test is so uncommon. With a totality of the circumstances test, you just analyze the voluntariness of the subsequent statements, and you say, were they voluntarily made? Now, I think with the evidentiary test, it's still proper to have some sort of a causation requirement. That yes, the evidentiary test would say, if we keep it, would say that we're not concerned with the precise magnitude of the effect, but there does need to be some sort of effect on the later statements from the earlier improper promise of leniency in order to justify suppression or warrant suppression.
Oregon versus Elstad. I mean, we need a standard. I mean, because it's an issue we haven't addressed before. We're the ones who adopted the evidentiary test, but we don't have sort of a break in the action standard.
I think Elstad makes sense. I think that looking at the voluntariness of the subsequent statement makes sense in a totality of the circumstances way. If this court disagrees, at the very least, there should be a causal connection requirement. I would point out that
to show causation, would the subsequent statements have to relate to the initial promise? How would we measure that?
I think that it would have to relate in a way that leads, I mean, even going back to Mullen, the language that seems to have fallen out. Mullen initially said, as part of its three-part test at the end, that will these statements likely cause a false confession? That's like the basic test for promise of leniency. So you would apply that as a causation requirement to, and it's going to be fact dependent, but connection between the subject matter of the promise and the later statement matters. Intellectual sophistication, the degree to which there's going to be a fact-based inquiry into the degree of the causation or broken by attenuation. I'd point out that during that second interview, she brings up, are you going to arrest me now? They don't mention that. She mentions that at least twice. And then the officers then say, well, we don't know. We have to communicate with our boss. So the reason I bring this up is, A, I think that shows that she's not under the effect of a promise of leniency. So if you're looking at either a totality analysis or a causal connection, I think that helps establish that there's no ongoing taint from any earlier promise of leniency. But I'm sorry, I see my time's expired. If I could briefly conclude this point. Thank you. But second, if you don't think what happened at the end of the first interview was effective at dispelling any promise of leniency, definitely that conversation where they say, yeah, you might be arrested based on what you've just told us, at least that would dissipate it. And so then all of her subsequent statements would be free of that taint and would be admissible. That's how I'd handle that issue, I suppose. Thank you.
Ms. Gentry?
Thank you, Your Honors, and may it please the court, counsel. Tammy Gentry, on behalf of Goen Park. Ms. Park is here with me in the galley today. The totality of the circumstances support that Ms. Park's statements in her interviews at the police station were not voluntary, as a police overbore Ms. Park's free will and constituted a due process violation. Further, the promises of lenience were pervasive. If Ms. Park simply tells the police that she was reacting to an abusive situation, that, in the officer's words, that makes sense. That makes perfect sense. We'll put a bow on this and be done. Those promises were not revoked at any time. As such,
Let me ask you kind of the same line of question I was asking Mr. Sloven. So at the end of the interview that contains what the Court of Appeals and the District Court found were, or at least the Court of Appeals found, were promises of leniency. One of the officers says, "You're lying. I know you're lying. We're not going to be done with this. You know, this isn't over." She leaves. She then comes back 8 hours later voluntarily. They're not even expecting her. She's Mirandized, composed. No identifiable promises of leniency in that interview, in what we could call the third interview, the second interview, depending on account. Why is that suppressed?
I would state, Your Honor, we think you're lying came on the heels of all of these statements of leniency, including just after their final statement where they'll say, we're going to put a bow on this and be done. What they did not say is, we think you're lying, we're not going to help you. We think we're lying, we're not going to protect you. We think you're lying, we don't think you're a battered woman. I think we have to take that into the context of all of the promises of lenience that preceded them stating that you're lying. And
for when a promise of, when does a promise of leniency dissipate? I mean, what is your standard? If we're looking, we have one statement with a promise of leniency, we have another one later where no promise is made. At some point it needs to dissipate, I'm guessing. What would your test be?
I think there needs to be a clear rescission of that promise of lenience, which we didn't have here. I think we do have some authority in some of our previous cases. Believe the case, the interviewee or the suspect talked to a lawyer in between the first and second interviews, and that was determined that the promise didn't dissipate. In the Zerat
Rescission, you're saying there needs to be a clear rescission. So are you saying the officer says, everything I told you about compassion for domestic violence is withdrawn? I mean, what do you mean by a rescission? The comments he made were based on her being truthful, and then he eventually said, you're lying.
The comments he made, I believe, were based more on presenting a narrative that she is a battered woman, and if she simply tells them what they did, they're going to help her. That was not revoked.
Counsel, what do you make of the argument that that the state brings forth that there's an extrinsic benefit and an intrinsic benefit, and that what the detectives were really talking about here was an intrinsic benefit to her in truth-telling, and that it's going to be better for her to have sort of a clean, truthful story that she's putting out instead of some extrinsic benefit, which is if you do this, there's going to be sort of a quid pro quo of, some defense that you might have or leniency.
As we know from the Howard case, there doesn't have to actually be a quid pro quo. And so the court needs to look at this from objectively any types of promises, any types of indications, strong indications of lenience can affect that person. So they didn't just say once, Your Justice, how can we help you? They said that multiple times. We are here to help you. We are here to protect you. I would do something similar if I was in that situation. People would understand. So this wasn't just one kind of offhand offer to help, but a pervasive offers to help that I think in their totality come to a promise of lenience.
I'm going to switch gears on you. So there's leniency and deception here, at least there's kind of two sort of broader categories. On the deception side of it, when they're telling her, we don't know the status of your husband, and she's asking about it, and they keep saying that they don't know, the state presses pretty hard on this notion that she doesn't say, while this deception is going on, okay, I did it, and, I put this poison in his drink, or I did it, and here's what you need to do to help him because this is what I did to him. There's nothing like that. Instead, she sort of stands firm with her story, and it isn't until after she finds out that he's passed that, the problematic statements are made here. And so what do we make of the fact that the deception didn't work?
Well, I think that, one, the deception here was somewhat more emphasized than in the Jacoby case or in the Cooper case, in that they are tying that deception directly, not just to the empathy of not knowing whether your husband is alive or dead, but you need to tell us information about this event so that we can help the doctors to help your husband, drawing even deeper into that deception. And then to go further with that, I think the U.S. Supreme Court in the Rogers case has been clear that the voluntariness of a statement or of a confession is not determinative of the relative truth or untruthfulness of what the defendant states and makes in their statement. So I don't know that we're actually looking at, did she give an entire confession? The Rogers case says that the truth or untruthfulness is not a factor here. That said, I do believe that Ms. Park made some inculpatory statements here that the state wants to utilize against her. I would briefly request the court on this appeal to additionally review these statements at the apartment. I believe the court has the authority to do that the Court of Appeals reversed on. So I would make that request to the court for the review of that Ms. Park was in custody at the time she made the statements at her apartment.
Is it possible that the scope of the ruling may be too broad? I think, at least as a very practical matter, I think the thing I'm struggling with in this case is you have very long interviews conducted over several different incidents, and to treat them as if it were one single interview conducted at the police station or conducted at the house, where you say, okay, after this particular statement, 29 minutes into the interview, everything else is inadmissible. And I wonder if, given the unique circumstances of this case, that maybe some of this needs to be done statement by statement, maybe during the course of trial or as it gets closer to trial. So there's a more focused analysis of kind of these issues about causation, promises of leniency, whether it induced a statement at issue or not. That's just my very practical concern. And I don't know if you could address kind of that problem for me.
I do believe that the voluntariness issue would take out the entirety of the interview. And if the court determines there's a due process violation with the voluntariness, I believe that would additionally lead, even if the court determined that there was not a promise of lenience issue, that would also taint the subsequent issues, or the subsequent interviews with the police. I think that
If we find that the statements are involuntary, all of them, over all the interviews, then they should all be excluded. I'm not sure I'm there, but, I don't know how we address kind of all of these 10 hours of statements, kind of with a blanket ruling because the officer said something at minute 29. Therefore, the statement made 9 hours in is also inadmissible. That's really the practical issue I'm struggling with.
that juncture would need to look at, was there a cessation in the promise of lenience? Was there a revocation of their promise of lenience? There were several interviews. I certainly don't disagree with that. But at no time, Justice, can I point to a revocation of that promise of lenience. I think your point may have more credence if there was an express revocation of that promise.
Hearing that, I was just looking at case which you cited and just mentioned to me. I mean, it's a different situation. There you had a very clear and direct promise of leniency. If you tell us what happened, you won't be charged with murder. If you don't, you will be charged, all right? And so then the court says, well, the fact that she then consulted with an attorney and came back and made more statements, we're not going to suppress those more statements because the psychological effects would still be there from the promise of leniency. Where you have here, again, at best, a more nuanced, shall we say, promise of leniency, if there was one. Again, why do we suppress something where she comes back, she's told at the very end, you're lying, we're not done with you. She then comes back 8 hours later, completely on her own, and is Mirandized and makes a statement. It's really it strikes me there's no issue of voluntariness in that particular statement. It's just one of, was she under the influence of the promise of leniency, if there was one, right?
Would also be entitled to look at, was she under the influence of the previous, also involuntary statement. If that first interview was determined to be involuntary, which we are urging, then their second interview, only 8 hours later, I believe Elstead would support, would also be an involuntary statement. So
I assume she went home, was well rested. Sounds to me like she came the next day on her own. I'm not sure if she called ahead of time or just did a drop-in, but was re-Mirandized. At what point, and you know the record better than I did she either, was it after the fourth interview, did she say, I want a lawyer, or was she arrested after the fourth? Did she ever say, I want a lawyer?
well, she did ask about a lawyer, Your Honor, in the first interview at the police station. Subsequent to that, I cannot cite to where she said that she wanted a lawyer. At the final interview at the police station, she was arrested at the conclusion of the interview.
Mirandized, am I correct, 4 separate times?
3 times.
One call, I think, if I'm correct. And if we just call that at the 911 statements, and then beyond that, I think, in my mind, I've been calling them first, second, third, and fourth interview. Wasn't she Mirandized each and every time?
She did receive Miranda warnings. I think there was only 3 subsequent interviews then with the police.
Then there was a second one where she came to the police department, and then there was a third at the police department, and then she voluntarily came to the police department again a 4th time. Wasn't she Mirandized each and every time?
was read a Miranda warning each and every time. And the first one at the police station, as the court knows, we are urging that that was not made knowingly or voluntarily, but the police officer did read a Miranda warning at that first interview, yes.
Thank you.
I just also wanted to clarify that the state did make one statement where, on the issue of the deception, where they said that the officers made no statement like that he had recovered to allow her to believe that he wasn't deceased right at the time that she at the apartment. Partway through the interview, after the police have told Ms. Park that Mr. Nam is deceased, they did tell her deceptively. She did talk to the medics. What do you think that she said to the medics? So they did lead her to believe that she made statements to the medics.
Watching that part, and she didn't buy that one. I mean, she didn't believe that. I agree it's an evidentiary well, it's a deception. It's a voluntariness, but isn't it fair to say that that's just dropped and there's no indication that she believed that?
I can't say that that was my interpretation of it, Your Honor.
Mr. Sloven?
May it please the court.
This question. Does the state recognize a battered woman's defense to murder?
This
Recognize a battered woman's defense to murder?
that have, it specifically helps establish subjective reasonableness. I think we've gone back and forth on its impact on objective reasonableness, but I think it potentially could.
Relevant in some circumstances, but it's not a defense, a standalone justification that my spouse.
It doesn't stand separately from the it doesn't stand separately from the justification defense.
Questioning given the state of our law, what is the relevance of the police officer telling her that if she were a battered woman, it's okay? People would understand. I would do it too. And he specifically mentions, we've been watching, you watch Lifetime movies, there's a battered woman, she has to do something, maybe she poisons her husband, and then he says, people get that, I would do something too. It seems to me that's a fairly direct implication that if you're a battered woman and you did something like poison your spouse or kill your spouse, then that's okay. And if that is the implication, that's wrong and false, correct?
Things on that. The first is that empathy and understanding doesn't have to have a legal import. It's cathartic, it's building rapport, it's communicative, it builds a permission structure to make admissions that aren't, that out of the desire to know and be known, to be understood. That's a good kind of confession. That's something the law encourages. But to your point about a deceptive statement about the law, I think that a deceptive statement about the law is kind of in this nexus between a promise of leniency and deception, where deceptive statements about what would establish particular defenses. Now, sometimes they're promises of leniency where the officer says, if you tell us that you didn't pull the trigger, you won't be in any trouble, right? But sometimes they're not as promises of leniency, they're as deceptive statements about, if this is what you did, then that wouldn't be a crime.
Statement, I would do this too, as a peace officer, doesn't that imply that it's lawful?
It carries some implication of that, although in the context of it, the way that it's, he's not talking about charges, he's not talking about trials or punishments.
Case, a sex abuse case involving a minor, and if the officer said, if the minor seduced you, that would be okay. And if she seduced me, I would have fallen for the same thing. People understand. Are you saying that kind of statement would be permissible?
That would be okay. That's trickier, but I understand that. People understand that. Those are flatly permissible statements that
I also would have had sex with this minor.
So that's trickier. I think you're hitting on something that I think strikes a valid chord, which is that when an officer says, I would have done the same thing, that does carry a little bit of, it can carry a bit of approval of, but I think that in the context of all of the other statements that were made together with it, it's clearer that they're communicating empathy and understanding for her position generally, and that this is an understandable position to be in, and that general kind of reaction is, I mean, nobody was saying that she poisoned him, right? That was just kind of a general kind of this situation that they were bringing up to say, we understand, we empathize generally with that position. So I think it's concerning on some level, but not a promise of leniency. I want to clarify on the record.
Talking about, it's the one, if I was getting treated like that, I would do something to make it stop. Is that the one we're talking about?
I mean, I think that is itself indefinite and conveying empathy and understanding. I'm not sure if that was the one, but there's so many of these statements, and I think that highlights, Justice McDonald, the need for an approach that helps identify the effect of a promise of leniency in some way, at least when we're dealing with multiple interviews and long statements. And
Mr. Sloven, wouldn't it be, I would do something to make it stop too. If we're going to look at this subjectively, couldn't we also say, well, maybe that idea would be to get a protective order or to get the hell out of Dodge? But I think there would be more ways of interpreting it.
Yeah, it doesn't, I don't see the officer saying, kill him. Yeah.
Immediately preceding sentence is, she poisons him. She does something to make it stop. I don't think he's talking about getting a protective order or calling the police. It's pretty clear he's talking about killing the spouse. I mean, do you disagree with that as an inference from that statement?
that, and if I can have more time to respond, I think that actually highlights kind of the distinction that's being drawn in that between legal justification and understanding and empathy with the person in that situation. For an officer to say, yes, it's legally justified for you to poison this person, like a cold-blooded type killing, like that, by common sense, that's just not something that's not a way that a person would interpret that remark. Like, yeah, people would understand it's tragic. So I think that kind of highlights that, A, we're in the hypothetical and we're still talking about would do something, but even in that hypothetical, it's distinct from the issue of legal justification. And even there, we're still not talking about an extrinsic benefit tied to an admission rather than the underlying truth of the facts that happened. It was said that Howard doesn't, or our cases don't require a quid pro quo. Even for an implied promise of leniency, there has to be a quid pro quo admission in exchange for benefit. It can be implied from all of the statements taken together, but there has to be a quid pro quo. That's the essence of the problem with reliability.
With a practical question I raised, how would that be administered at trial? Like, if we can't at the very outset do kind of this shotgun blast approach with all of these statements made over all of this time, how would that actually be administered during the course of trial if we were to take a narrower approach?
Be litigated before trial and not in front of the jury, obviously, and then we would. Upon finding a promise of leniency, then I would imagine that the burden would shift to the state on some level to identify particular interviews or statements that were unaffected by that promise of leniency and show why, or the same way that burden's initially on the state to establish voluntariness of statements. And it could be a LSTAT type voluntariness analysis, just totality of the circumstances. Courts are experienced in applying those tests. Or it could be just a causal connection test, but either way, at least having a standard would make it possible for courts to identify, same way we do with vouching, identify statements with particularity, go through, apply the test and say, these are admissible, these aren't, and then retrospectively, we can do a harmless error analysis, and if they got almost all of them correct, and the ones that they missed are cumulative or harmless, then, so, thank you.
State versus Park is hereby submitted. It is 10:27. We will take a break until 10:35.